Let's bring in our friend, criminal defense attorney DOD Ghassemkhani, who is live at the San Diego courthouse, who has been following this case along with us. DOD, so nice to have you on.
Thank you, Seema.
Okay, so you're a criminal defense attorney, and I'm sure you've heard the expression, delay is the defense's best friend. So what do you make of this? We're on day 4, and it's a Friday, and they've been out for almost 15 hours.
Well, Seema, that's a great question. Look, you've tried hundreds of cases. I've tried a lot of cases. And the one thing we know is we have no idea what the jury is thinking. I mean, we had 5 Jane Does they have to go through. They had several days of testimony that they have to go through. And sometimes you have a jury that's out for 4 or 5 days and they come back guilty across the board. Sometimes you have a jury that's out 4 to 5 days and they come back not guilty across the board. But what's striking about this case is the first few days, as was reported by CourtTV's Chanley Painter, the jury was getting along. They were talking, they were laughing, they seemed to be getting along, so it appears to me they had verdicts, at least for Jane Does 1, 2, and 3, but as of today, there seems to be a little bit of tension in the hallways prior to their deliberation. So at this point, I would not be surprised if, as it relates to Jane Doe 4, the jury is hopelessly deadlocked.
Okay, well, let's just remind the viewers. So there's 5 accusers in total. Jane Does 1, 2, and 4 have rape accusations. And Jane Doe number 3 is exposure, and Jane Doe number 5 is a lewd conduct. Okay, so and the Jane Doe number 3 and Jane Doe number 5 are the misdemeanors. So 1, 2, and 4 are the most serious charges. Kellen Winslow is facing life in prison if he is convicted. And if you look at these in total, okay, so you've got 5 accusers. Let's bring in the concept of what you and I both know is called splitting the baby. And a lot of times jurors will do this. Some jurors will say, okay, you know what, I'm guilty on Jane Doe number 1. Others will say, I'm guilty on Jane Doe number 2. Split the baby and let's find him not guilty on one set of charges and guilty on the other, and let's go home and call it a day. DOD, tell us how you reconcile this idea of going in and deliberating, and from all of your experience, what you know about this concept of how jurors split the baby when they have so many charges to consider. In this case, they have 12 charges to consider.
Well, absolutely, and that happens a lot of times in these criminal cases, and I think that's the reason why Mark Carlos in his closing argument spent so much time on Jane Doe number 1. In his closing argument, 40 minutes of that went to Jane Doe 1, and I think they're trying to get the not guilty on Jane Doe 1, because if they get the not guilty on Jane Doe 1, then that takes him out of the 25 to life range. So that was the plan behind Mark Carlos's 40-minute closing argument as it relates to Jane Doe 1.
Okay, let's go through this note that the jury put out this afternoon, just a few hours ago. They read it, and the first part of the note says the jurors could benefit from an explanation as to what being under oath means. What kind of explanation could they have gotten? I mean, isn't it just being under oath means being under oath, tell the truth? It's pretty simple, no?
You know, Seema, I'm pretty perplexed as it is. What does it mean to be under oath? To be under oath means you're under oath and you have to tell the truth. So to have that question being asked, to me, what it seems like is they have some sort of holdup on Jane Doe number 4's testimony. But whenever you get a question like that, whenever a juror is asking, well, what does it mean to be under oath? It appears that they're trying to do whatever they can to find Mr. Winslow guilty.
Oh, okay. Okay, but wait, why do you say Jane Doe number 4? Are you attaching this note to the previous note that asked for Jane Doe number 4's readback and her friend Nicole Edwards' readback?
I am. I think the way the case has gone and the way the case was presented and the way Dan Owens did his closing and the way Mark Carlos did his closing argument, they went in order, Jane Doe's 1 through 5. So I'm of the belief that as of right now, they've gone through Jane Doe 1 through 3. Whether it's guilty or not guilty on any of those 3, they have a verdict. And now their holdup is on Jane Doe number 4.
Okay, I'm just going to throw this out there because I've asked plenty of people. Nobody's buying it. So let's see what you have to say, Dodd. Is there any chance that they're going chronologically, starting with Jane Doe number 4 because it happened in 2003, and that's where they've been for 4 days?
I don't think so. I think just the way the case was presented and how Mr. Owens presented his case and the order in which the witnesses testified and how they presented their closing argument, I think they're just going in order with the way Dan Owens and Mark Carlos presented their case. I don't see them being stuck on Jane Doe number 4 for the past 3 days.
No, I'm sure you're right. I'm the only person who's putting this out there because I want to know what's going on in that room. It's driving me nuts. Okay, let's just review the next part of that note.
That's the million-dollar question.
It is, sir. The next part of the note says, how should we follow the law and not what we think the law should mean? I thought this judge was crystal clear during voir dire, during that whole jury selection process, asking these jurors, can you follow the law as I give it to you? You find the facts, I tell you what the law is, can you follow the law? And they all said yes. So how do we explain this second part of this note?
I mean, to be honest with you, I think that note is pretty troubling. I mean, in any jury selection, the first thing the judge tells them is, can you follow the law? Even if you disagree with the law, can you follow the law? During jury instructions, again, the judge instructed them, you must follow the law as I tell you what the law is. But it seems like here with that jury note, they're trying to apply the law as they think fits.
Okay, Dodd Ghassemkhani, thank you so much. I hope you'll stick around so we can follow up later with some more of your legal insight. Thank you, my friend. And next up, the entire CourtTV anchor team joins me right here on set for this verdict watch. We are in a countdown, folks. 15 hours approaching. Star NFL athlete, fame, fortune, and it all just vanished.
Kellen Winslow II, unbelievable story. He's accused of being a serial sex offender. There are 5 different women who are accusing him of various offenses, including forcible rape.
He goes, if you don't do this, I'm going to kill you.
Winslow denies all charges and claims the women are just after his money.
When you're in the spotlight, people want things from you.
He was a good teammate, reliable teammate. I don't see it happening.
I told him to stop. She described the vehicle as a large black Jeep.
We know this from the digging that our CourtTV team did prior to this trial.
This is the area that she says Winslow brought her to.
This is a part of the story that is getting unusual, to say the least.
It's very hard for us to put ourselves in the criminal mind.
Tonight on CourtTV.
Verdict watch continues in the trial of Kellen Winslow II after the jury requested a readback of Jane Doe number 4's testimony. Are they any closer to reaching a verdict? Stay with CourtTV for the latest news, and we'll break down every development as we move closer to Winslow's verdict on all 12 counts of sexual misconduct. We're live in San Diego for the final moments in this trial.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new CourtTV.
Your duty as a juror is to decide the facts that have been proven and to follow the law. Once you decide the facts, using your common sense, your good judgment as members of the community, your life experience in knowing that lightning certainly doesn't strike twice, let alone 5 times, and you join together in one voice after reviewing all of the facts, after following the law that's been provided to you by the court, and you have one job to do. You have a privilege and you have a responsibility as members of the community to find this defendant guilty, because that's what's been proven.
Welcome back to CourtTV Live. We're on a verdict watch approaching 15 hours over the span of 4 days. The entire CourtTV anchor team is here with me, Yodit, Vinny, and Julie. Okay, so let's talk about the latest note. We all have a copy of it right here. The jurors just sent this out. Julie, they sent this out during your show, right?
They did. Yes, they did.
And was that during the readback of the...
Well, here's when it was. So they went to take a break during the readback, a little 10-minute break. It was at a natural point after they had heard the testimony of Jane Doe number 4, and the court reporter was going to move on to the testimony of Nicole Edwards. They thought that was a natural time to pause. On the way out, juror number 6, who's the 4-person, handed a note to the bailiff to then give to the judge. So when they were on a break, the judge looked at that note that we have here now asking for further instruction on what it means to be under oath and then to follow the law.
Do you think... Wait, was this note pre-written?
Well, I don't
when they
know
came in this morning?
when it was written. No, I don't know that. And of course, I think there probably would be no way to know
okay, because you said
done in the jury box because they're allowed to take notes during the readback. So, but what I'm just saying is they were listening to the readback. There was a natural break because they had just concluded with Jane Doe number 4. They were moving on to Nicole Edwards. So the judge said, "This is a great time to break. Give the stenographer a break." And on their way out of the room,
he handed the note.
He passed the note to the bailiff.
Oh, so he could have written this while sitting there listening to the readback.
Sure.
Could have.
Yeah,
That
you know
wouldn't
what that
be
means.
a good way to do it. They're supposed to do it as a group and send out the note, unless he had the note and he came in and he didn't hand it in until halftime. It's strange. And the questions are interesting as well.
Why don't you feel free to read them, Vincent?
Well, the jurors could benefit from an explanation as to what being under oath means. And there is no other meaning of being under oath other than being under oath. So,
Yo, Dee, give me an alternative facts to what is.
No, we
under
don't
oath
do
mean?
alternative
But there's
facts here at
statements
CourtTV.
made. But there are statements that were made, like there's statements that are made to police officers that aren't necessarily under oath. So I think there could be an explanation made,
It's
but I don't know
so
if they will.
simple, y'all. They were getting the readback of juror number 4's testimony. They clearly don't believe some aspects of her testimony, and now they're asking, what does it mean to be under oath? That's what that means.
I think they're wanting to know the significance of it. And why I say this is because we heard some impeachments, and all of you know this, at the start of an impeachment, you're going to say, you remember giving testimony at a hearing, previous hearing prior to this trial, right? And the person answered yes. And you remember that date was such and such a date. Yes. And on that date, before you testified, you took an oath, right? Yes. It was an oath to tell the truth, right? You swore that would be the truth on that date. Yes. So there's emphasis on taking that oath because for lawyers, we want to use that statement to bring it into court to contradict what was said at trial. So I wonder if during the readback, and again, this is just an educated guess, I wonder if they're getting hung up on, wow, why was there so much focus by the attorneys on asking the witnesses about being under oath, taking that oath at the preliminary hearings?
But do you think this is a question about all the witnesses, a general question, or do you think what Yodit thinks, which is this question was precipitated by the Jane Doe 4 readback? Julie, what do you think?
I think it came from the Jane Doe 4 readback. And maybe it came after yesterday because we know we heard a large portion of it yesterday, most of it yesterday. And so I think that was where it came from. Otherwise, I think we would have seen it on the question asking for the readback and for that exhibit number 154.
And it could be they're giving different weight to different statements. Maybe a statement for this jury under oath, someone's saying in that jury room that's what you have to worry about. You don't worry about the statements that aren't made under oath. You worry about the ones that are made under oath. Like maybe they're somehow distinguishing between those types of statements. Maybe.
Okay, so like some of the statements made to law enforcement, and there was constant, it looks like all the witnesses and the Jane Does, there's constant back and forth of you said this to law enforcement, you said this to the lawyer, you said this to the nurse, you said this to the investigator.
Right. And some of the jury room said, but it wasn't under oath.
It's so odd. You should just tell the truth regardless. It shouldn't be a situation where you're either under oath or not. If you're telling a story about an alleged rape or lewd conduct, you should be telling the truth regardless. So I think that they're trying to wiggle. I feel like they're trying to convict Winslow on a particular case, a particular count. And
do you think it's Jane Doe 4?
Yes.
Okay.
And I think they're having a problem, and that leads to the second question.
Okay, let's talk about the second question. Vincent, dramatic reading,
Additionally,
please.
how should we follow the law and not what we think the law should mean?
I can't with that question.
I would send back and please clarify your question.
No,
you don't need to. The judge went. Go ahead.
They don't like the facts that they have and the evidence that they have because it doesn't fit the actual the law. So they want the law because they want the law to go with what they want to do and they want to convict. I just don't think that they have the facts and the evidence that would allow a conviction on whatever case. We don't know what count. Could be Jane Doe number 4. Don't know. Right? I'm speculating it is Jane Doe number 4 because we haven't heard anything.
So
about
you're saying following the law leads to not guilty?
Yes.
Okay. Pause. Julie, didn't the judge during voir dire make this crystal clear?
Yes,
Like,
yes.
can you follow the law? Yes. Can you follow the law? Yes. Okay, you're on the jury. Why are we doing this now? What's happening?
Abundantly clear, yes, most definitely. And that would be a prerequisite to serving on this jury. This is something they all said that they could do, and that was something he reminded them of that, hey, if we're in a place now and somebody's saying they can't follow the law, he's saying, as the judge presiding over this case, I need to know, because this is hugely problematic if that is the case, if there is a juror who's refusing to do that, because that is part of the oath, part of the duty that they have to uphold.
Okay, now that we're talking about Jane Doe number 4, because that was the last, there was something interesting that Julia Janae, our crime and justice reporter, noticed. Let's actually start by listening to some sound from Jane Doe number 4 when she testified.
Did you continue to tell him to stop?
Yes.
You say that he kept doing it. What was he doing?
He was still having sex with me.
Now that he's having sex with you, are you facing each other?
Yes.
What happened after he continued having sex with you as you were on your back?
He stops.
Do you know why he stopped?
Because Matt.
Objection. Speculation.
Overruled. You can continue.
Because Matt told him to stop. Just stop.
After Matt told him to stop, did Kellen finally stop having sex with you?
Yes.
Did he say anything to you when he stopped?
No.
What happened after you saw Matt telling Mr. Winslow to stop?
Kellen gets off of me and moves to my right. And then I see somebody else standing behind him. That wasn't Matt.
Did Kellen leave the room?
Yes.
What happened after Kellen left the room?
Matt started to help me get dressed.
After Matt started to help you get dressed, did Kellen come back into the room at all?
He looked, I don't know if he came in fully, but I know he came back. And he says, she's just a stupid bitch. And then closes the door.
Okay, I just want to point out to everybody that when Jane Doe number 4 was saying Winslow said stupid bitch, Winslow just put his head down and that was his reaction. Now we're going to take a look at that same testimony on readback and pay attention to Winslow's behavior.
Question. What happened after Kellen left the room? Answer. Matt started to help me get dressed. Question. After Matt started to help you get dressed, did Kellen come back into the room at all? Answer. He looked, I don't know if he came in fully, but I know he came in back.
Okay, we have one more version of that. One more.
After Matt started to help you get dressed, did Kellen come back into the room at all? Answer. He looked, I don't know if he came in fully, but I know he came in back, and he says, she's just a stupid bitch, and then closes the door.
Okay, so it's interesting that he had this visceral, although subtle, reaction to the readback, but during the actual live testimony, head down, nothing. What do you make of that?
I don't know. I mean, horrible timing, that's for sure. You're not helping. I mean, if you wanted to make some sort of a reaction or communicate through your actions to the jury, I would have done it during the jury trial so that they would know you disagreed with that statement. But to do it there, actually, wait, no, the jurors are in there.
Yes.
Yeah. So wait, I'm forgetting. Sorry, guys. Rewind.
No,
My bad.
yeah.
Yes.
No, wait, listen.
Should we read that back?
Yeah, we need to read your deed back.
But that was subtle. Who knows if the jury even saw that?
Yeah, I don't think
because Julia Janae noticed it, and I thought it was something.
But I don't think he was doing it for anyone. It seemed very authentic and natural. Whatever he was thinking.
No, I think that's the point. That it was an authentic, natural reaction. Okay. Julie,
definitely. We definitely all noticed. We were commenting on this when I was on the desk during the midday show that he's much more expressive during the readback, and who knows if maybe he's feeling some hope from this. Maybe he's reading this in a way that he's thinking this is good, that they have not returned a verdict at this point, that they're being so thorough, as the judge pointed out, they're being so thorough in their examination of the evidence, and what more can you want?
Maybe he's being more expressive because he's not intimidated by the Jane Does, the actual people testifying.
Or,
he's like,
or doesn't want to come off like he's intimidating. the Jane Doe on the stand.
Also,
So
excellent point.
horrible
Excellent
look if
point.
that was right.
Okay,
Great point.
coming up, all of the anchors, we're all going to dissect Kellen Winslow, his present as well as his past. Verdict Watch continues. We're approaching 15 hours. It's day 4.
I just grew up as a boy, 5-year-old boy who had a dream, and always had a ball in my hand. Wanted to be like my dad. Grew up watching my dad's tapes. Wanted to be like Jerry Rice, and that's the reason I wore 81, because I wanted to be one better than them. I wanted to be one better than my dad.
That's Kellen Winslow II. He is facing life in prison if he's convicted of rape and other sexual misconduct charges. We're on a verdict watch, folks. It's almost hour 15. The jury is out to lunch, but the anchors are not. We are sitting here and we are dissecting. And let's start off with Kellen Winslow II. You know, there's so much we know about him in generalities, but Vinny, you know probably the most about his background being an NFL fan. Can you just enlighten us a little bit, especially with respect to that clip we just saw? And
that's interesting, because that talks a lot about the relationship, right? That he admired his father and he grew up watching his father's tapes because he didn't watch them live because he was too young, or maybe he wasn't even born yet. And the fact that he wanted to be one better than his father, that could be interpreted in many different ways. From what we've seen at the trial, though, Senior is there every day for his son, so that is a strong bond, and he is there for his son no matter what, unconditionally. And, you know, that would be a statement that me as a father I would make to my son. I wouldn't want my son necessarily make that he wanted to be one better than me. That I say, I want you to be one better than
yes,
than
right,
I
exactly.
was.
That's why
So I want you to wear 81. Whereas this is coming the opposite direction, which is a little, I don't know, a little funky.
I felt the same way. When I first heard that clip, I felt uncomfortable. I felt like there was some underlying tension there.
Yeah, you don't really have this sort of tense competitive nature with your parent. Usually your parents, you know, in how they raise you, want you to learn from your mistakes and make, you know, be better parents and, you know. So, yeah, they would want you to do better in your life than they did, right? But it was sort of this unhealthy, almost competitive nature he had with his father, probably obviously one-sided, and almost like he had a chip on his shoulder.
Well, okay, so you say obviously one-sided. Julie, isn't it possible that Kellen Winslow Sr. is coming to court every day, doing what's right for the family, for the Winslow name, but it doesn't necessarily mean that behind closed doors he's not seething with anger and disappointment at these charges?
Sure. You know, who knows? And it's been tough to get a reaction from him. We've watched him closely, but understandably so, that he's wanted his privacy and to just show that he's supporting his son. I think it's just, it speaks volumes about the love he has for his child. At the end of the day, that is his baby. No matter how old he is or how horrific the allegations are, that's his baby boy, and he's going to show that unconditional love. I feel like there's nothing like the love parents have for their children, and I think just him being there day after day, even yesterday, you know, for questions to be read back, he's there today for questions. It just shows how committed he is to showing his son, look, I'm there for you. My support is unwavering.
Yeah, and I mean, as a parent, whatever it takes, we'll figure it out. You know, whatever the problem is, we will figure it out. And part of figuring it out for this family is to try to have him not sentenced to life in prison. And that's why I'm convinced that's why Dad
also
is there.
there's 2 grandchildren involved, so that part of maybe Winslow Sr.'s motivation is to protect those grandchildren. Let's actually listen to a clip we have of Kellen Winslow II, and this is when he is outside the courthouse.
Is there anything you want to say to your fans out there and everybody that's out there?
Yeah, man, I'm innocent, you know. To the people that know me out there, know what type of person I am. You know, my character, my NFL friends and family, and just my regular friends and family. They know who I am, and I'm an innocent guy. I'm an innocent man.
This must be an emotional process for you and your family, having these accusations being brought from 3 different folks now.
Yeah.
How do you process this?
It's a money grab. It's a money grab, and unfortunately, that's the society we live in now, and you know, that's all I got. That's all I got. Thanks.
Okay, so actually that clip was from last summer because they said 3 accusers, so that was clearly before Jane Doe number 4 and 5 got in the mix. And okay, so does he seem, I'm going to try not to lead you, okay? I'm trying not to ask leading questions.
Objection.
Yeah, exactly. But does he seem different in demeanor and personality than you've seen in the courtroom, Yodit?
No, I think he seems kind of on par. Like he's
Really?
Yeah, I mean, he can't say much sitting at the defense table, but I mean, he's got himself composed. He wasn't really making facials. He was doodling a lot, and I think that was to keep him from making facials or shaking his head. I think and I saw moments where he wanted to laugh, especially when Jane Doe 1 was on the stand.
Yeah.
In those embarrassing moments where she was describing his manhood, I think he wanted to laugh. There were moments where I saw some, where he wasn't being really sensitive to the situation, so he put his head down a whole lot. But no, just sort of calm.
Julie, I know you took a lot of notes on Winslow's demeanor and the changes in his demeanor. Do you think any of that is consistent with how he was, and this was last summer in front of the courthouse when he was a free man?
Right.
Wasn't incarcerated.
Right, big difference, yes. And you probably hit the nail right on the head, Vinny. Big difference being incarcerated. What we're not seeing, we're seeing him in court dressed up in his suit. But after these proceedings are over every day, he's going back to the jail cell where he has been since February. This is a remarkably different lifestyle than he's used to. He grew up with a life of privilege, being the son of an NFL great, and then being an NFL great himself. For all those years, nearly 10 years, over $40 million is what he made. So this is a real shock to his system, I'm sure. And the day that I noticed he was remarkably different in terms of expression and a nervous appearance was the day where he had to tell the court whether or not he was going to testify because the judge needed to give those instructions accordingly. And I felt like that was the day I really saw changes in his behavior that were perceptible.
I personally think I wonder what he's going through. I always wonder, what is he going through, what the jurors are going through, what the parents are going through. But I think it's really difficult for us to understand someone who, if he's convicted, who's engaged, because we know all the other cases that the jury doesn't know about.
Right.
So we know a lot more than the jury knows about all those cases that dismissed, and some involved lewd conduct or exposure. There was the burglary cases. So knowing all of that, it is hard to get inside the criminal mind.
Yeah, well, here's the thing. I always look at it from two perspectives, and especially this time of the trial. What is it like sitting there? Number one, if he's factually innocent. If this is someone who's wrongfully accused, what are you thinking? And that's much different than someone who knows that they're guilty and they did it, what their mindset is. So it's two completely different mindsets dependent upon whether or not they are factually innocent. Not guilty,
Okay,
but factually innocent of the charges.
Before we have to wrap up this segment, I just want to play, because this is interesting. We have some sound from a journalist, Bryce Miller, and this is talking about Kellen Winslow II in 2001.
There was a fight involving kids at a park, and he was involved in that, and there was a $3 million confidential settlement that came out of that case, but the attorney for the other student that allegedly was seriously injured by Kellen in that fight said there were $120,000 in medical bills.
So this is something, Yodit, that they don't know about. This started 2001, he's getting into fight. 2003, this accusation against Jane Doe 4. So we're not talking about someone who's 2018 to 2019 committing criminal conduct. We're talking about essentially a lifetime.
Well, I probably, even knowing that, I think the going into women's locker rooms, the residential burglary through an old woman's home, those kind of things, yes, probative. The fight when you're in high school with a kid that you beat up, I wouldn't say that was telling. But it could at least be an insight into what he's thinking right now, what his process is.
Maybe, right, and this is why the rules of evidence are set up the way they are, because we're not going to throw in all the evidence of someone's bad character while they're on trial for certain crimes. It just doesn't work that way. It's wrong because we don't want that to improperly influence the jury. There has to be specific reasons for they come in, exceptions, and the prosecutor tapped into one of those exceptions with intent, which he's using right now in this case with Jane Doe's 2 and 1, saying if you find there was intent with Jane Doe Doe number 2, you can carry that intent over to Jane Doe 1. So that's one of the specific exceptions laid out.
Thanks for my reminder. I forgot to do Professor Grant. Professor Grant segment.
Give me too
I know.
much credit.
And I forgot to do the Professor Grant segment.
You give me too much credit.
Anchors, thank you very much. I know you guys will be in the newsroom at the TVs because our verdict watch continues. That's right. Day 4, almost hour 15. We're not going anywhere, so don't you either. Welcome to Court TV Live. I'm Seema Iyer, and this is a verdict watch. It's day 4 of deliberations in the Kellen Winslow rape trial. The jury has had the case for almost 15 hours now. Let's bring in our Court TV legal correspondent, Chanley Painter, who is outside the courthouse. And we also have crime and justice reporter Julia Janae, who is busy inside the courthouse. We will get to her as soon as we can. But Chanley, let's start with you. So when we last left, the jurors are now out to lunch, but before they went out to lunch, there was yet another note. So most of the morning was spent with finishing the readback of Jane Doe number 4, then with the readback of Jane Doe number 4's friend, Nicole Edwards. And between the morning recess, juror number 6, who we believe is the foreperson, hands the bailiff, your friend Manny, a note. And the note is actually the third juror note. So if you can tell us what the note says, I know I have it here as well, and maybe we could just go by each part and break down how the judge responded to this very perplexing note.
Mm-hmm. Right, so this was just a quick handoff, just like you said. It was written on the notepad paper, torn off, and the Manny handed it to the judge. The judge didn't look too happy about it, but he addressed it as soon as they came back from their break, and basically the foreperson said, I think it would help this jury if we knew what under oath means. And then the second part had to do with something, how to follow the law and not what we think the law should be. It wasn't technically a question, more of a statement, but the judge did address both things as they returned from their break, and he did so after conferring with the attorneys to make sure they agreed with what he would say. And he did define under oath, swear to tell the truth, the whole truth, and nothing but the truth, and there's a consequence for not doing so. And then the second part said, referred them to the jury instruction that he gave them, Calcrim 400, that said they must follow the law. Even when they don't agree with what the law might be, that's their duty, that's their job. And so basically that's how the judge handled it. And then after we were all done, he also confirmed with the attorneys right at the very end after the jury left to go back to deliberate, are you okay with how I answered that? And they both were, Seema.
Was the judge a little short or snippy when answering that second part of the note? Because I remember during voir dire, during the jury selection process, he told the jury, he asked them, can you follow the law? Can you follow the law? Can you follow the law? And they all said yes. And that's how they got on the jury. So why is he having to go through this yet again?
Right, he made it very clear that if there's someone among you who is unable, for whatever reason that might be, to do what the law requires, even if he or she disagrees with it, let me know, he said, because I will deal with that, and we know what that means. But he made it very clear, and he did seem a little like, well, I've already told them this, but he made it clear again to them, Seema.
Let's actually listen to a bit of sound from Judge Bowman.
The next question, well, it's not really a question, it's a statement. It said, additionally, how we should follow the law and not what we think the law should mean. And we went over this. Now, it's been a while. It's been, 3.5 weeks since we went through jury selection. And if you recall back to those times, there was a question I put on that jury selection questionnaire that asks you if you can follow the law as the court explains it to you, even if you disagree with the law. And speaking of taking oath, you all said under oath that you could follow the law as the court explains it to you, even if you disagree with the law. And you may not remember, but I went through an explanation explaining that the law has to apply equally in every courtroom throughout the state of California. The law that applies in this courtroom has to apply in the courtroom down the hall. It has to apply in a courtroom down in Chula Vista within San Diego County. It has to apply in a courtroom up in Mammoth Lakes, California even. It's the same throughout the entire state. We cannot have a different law being applied in any courtroom anywhere in this state just because a juror or some jurors happen to disagree with that law. The court instructed you, you must follow the law as I explain it to you, even if you disagree with it. If you go back into that jury room and you look at CalCrim number 200, it says it right there in plain English. It says you must follow the law as I explain it to you, even if you disagree with it. It doesn't say you can follow the law or you may follow the law if you choose to. It is mandatory language that you absolutely must follow the law as I've explained it to you. Now, if anyone feels as though they can't follow the law as I explain it to you, I need to know about it. You send out a note. If someone doesn't feel they can follow the law, you send out a note and you let me know and we'll deal with it.
Chanley, that was as loud as I have ever heard Judge Bowman. He reminded them, you all said you could follow the law. He said the court instructed you that you must follow the law. And then he repeated that phrase, must follow the law, 3 times. And then when he refers to the California Code, he says it's there in plain English. So did you also notice, because you're the one who's been in the courtroom day and night, did you notice that his demeanor and his volume was quite different than what we've been used to?
He was emphasizing it very, very much. We just both listened to that, and you are correct. And the jury was responding. I noticed a couple of people nodding as he was saying those very words, and you could tell that it was resonating with a couple of them, maybe even affirming what a couple of them were trying to tell the others on the jury. But we do know, Seema, I just got word that the jury is back in the deliberation room right now. We just got that message from inside the courthouse, so they are continuing to deliberate, it looks like.
Yeah, our clock is back on. We are now approaching 14 hours and 48 minutes. And because the jury's back in the deliberation room, that means our crime and justice reporter, Julia Janae, is ready for me inside the courthouse. Julia, when did the jurors resume deliberations?
Seema, they resumed just about 5 minutes ago. They returned from lunch. There was a little bit of a discrepancy over whether they had an hour or an hour and a half. Some of the jurors weren't sure what they had agreed to, but now we know they agreed to an hour lunch, shorter than they've had in the past, but it's up to them. But we did see a few of these jurors who did not go to lunch, and specifically one that we talked about in the last hour, juror number 12, he did stay here in the hallway. He took a bathroom break and then sat in a bench just a few yards away from us. And this is where he stayed the entire time of that lunch by himself. No phone, as you've asked me before, and just seemed to be in thought.
Okay, so you know I'm very concerned about eating all the time. Food is important to me. Is this guy eating? This is making me very nervous.
You and me both.
Is he eating?
He did not leave for food, I can tell you that. And so if he is snacking, he doesn't have a bag, he doesn't have anything that he may be using. So I'm not sure. I'm not sure exactly if he is having food at another time, but this is the second time that we haven't seen him leave for lunch. And today, it was really noticeable to me. I'm trying to observe all of these jurors, but he is making it a lot easier for me to observe what he's doing. He spent a lot of time with his hands folded and his head down. There was even a time that I saw him wiping his eyes. Now, I'm battling a cold myself right now, so not trying to play anything into what that may have meant. I heard sniffles from him, so he may be dealing with some of the same things I'm dealing with, but just something noticeable that in this time where they are coming up on this many days of deliberation, that he was sitting, nothing extra with him, no books, no phone out, which you asked me earlier, they are allowed to have their phones. Many of them had their phones out when they walked through this hallway back into the jury room. So not that he's under any restriction not to have his phone, but he spent a lot of that time there near us with his hands folded, his head down, and it just seemed to be thinking or just taking a quiet time. There are other places in this courthouse that you can sit. They even have a room that is called the quiet room. There are some benches outside, so not sure why he has chosen to stay up here on this hall during this break that they get, but this is now 2 days in a row that he has done that, and again, staying away from the other jurors, even when they all did return from the lunch break.
Yes, I was wondering if he was at least reading something, but you answered that. Thank you. Now, can you just give us a little more description about the other 11 members of the jury and what you saw? How did their faces appear? Were they divided off in groups? Were they chatting? Anything at all, any insight would be really helpful.
Sure. Now, they did return from lunch a little bit staggered, so it was hard to tell if they were pairing off or not. They just all arrived, and they were way down at the end of this hall where they gathered, which is, again, away from where Juror 12 was. He was over here closer to us. But they all gathered down there, and once they walked through this hall, and we got a chance just to look at their faces, they all seem rather upbeat, a little bit more than they had earlier in the day to me. Some of them were still looking at their phone, probably dealing with some things before they go into the jury room and likely have to turn them off. But you didn't see anything pronounced from anyone. They were noticeably quieter than they have been. The bailiff has let them know that they have to keep their voices down when they are entering the jury room. So 3 days ago, he let them know they were getting a little loud and they had to keep their voices down. That's when they were especially chatty with each other. But today, that wasn't an issue. They were all very quiet, going back in to return to their deliberations.
Okay, Julia Janae, thank you so much. And I hope that you get to treat that cold and get some rest over the weekend, my friend. Thank you so much. Okay, so Verdict Watch is on. The jury is back to work, almost 15 hours. This is day 4, my friends. And now some good news. You can get some Court TV anywhere you go. Just go to our website, CourtTV.com, and you can find us on Roku, Amazon Fire TV, and Apple TV. You'll get the latest coverage of our current trials as well as our entire coverage of our debut trial, Georgia versus Christopher McNabb and Courtney Bell. Be right back. We are in a Verdict Watch approaching 15 hours over the span of 4 days, and we're still counting. The jury just got back from lunch, and they have gotten back to work. There have been 3 jury notes, and let me remind you, there are 5 accusers. 5 accusers accusing the NFL star Kellen Winslow II of multiple charges of rape and sexual misconduct, and Mr. Winslow is facing life in prison if he's convicted. Now, right now, we want to focus in on Jane Doe number 3. Like I said, there are 5 accusers, but we're going to focus right now on Jane Doe number 3 and the body cam video that the jury saw when the police officer arrived at her home after Kellen Winslow allegedly exposed himself to her, because this really, folks, it gives us a peek inside her front yard. And as you can see, check this out. It is very private. It is almost impossible to see how exactly Kellen Winslow II even knew that Jane Doe number 3 was even outside. How did he even know that she was outside working in her yard the day that she says he exposed himself to her? Now, this is where she says she was when he walked up to her, way back away from her driveway. Let's bring in Chanley Painter, our Court TV legal correspondent, who I believe went to this scene. Is that right, Chanley?
No, we did not go, but we've seen a lot of pictures and, of course, the video that were all introduced into evidence. And you're exactly right. It gives us a great idea of how private her front yard is and how important his path on his Strava cycling app would be to show that he went into her yard, because you really have to go into her yard, up her driveway and to the left to even see her garden, to see the flowers, and that she's even in there. She's a petite woman, and you make a great point. And I think that body cam video really told the jury more than what she was just saying, but where she lives and what it looks like.
Right, and also a lot more than this Strava map is showing, right? Because in the Strava map, someone could conclude that he was just riding by and happened to see her, and that's where their interactions took place. Right? Like, people would not know unless you're watching the video.
Exactly. What we learned by watching the video is that if you're on the public road, you wouldn't be able to see what he's doing or talking to her or their interactions or him allegedly exposing himself to her. And that was the first thing I thought of, and I'm sure the jury as well, watching that body cam video. It was very, very telling.
Chanley, do we know through her allegations whether Winslow got off his bike and was like, riding his bike, walking along with his bike to that area, to that garden area? Or did he ride the bike all the way up?
Well, from her testimony, what we learned is he left his bike, he propped it up against the fence, or it was more like a wall almost in her yard. He propped it up against that. Now, to do that, it's right next to the garage area. So he would be up into her driveway, prop up his bike there, and then walk into her garden area where all of her trees and flowers are, and based on what she told the jury.
And this body cam video is also very illuminating because I used to live in California, and you can really see it's so lush. There's so much greenery, and not just I'm not just talking about the environment or gardening, but the point is you can't see things because there's so much greenery, right? So it's not like living in a place where there's just apartments and you're just, you see the Starbucks and you see the store. Because there's so many trees and plants and everything is so lush, it's actually hard to see, and you're almost ducking and bobbing and weaving to get into that back area. And he's a really big guy.
He is a really big guy. In her testimony, she didn't even look up to him. Her culture and testimony, she didn't make eye contact and look up to him at the guy. And you're right, the terrain here is very, very lush and very, very green, and you can see that in the yard. And that's why this body cam video was so vital for the prosecution's case, because it takes you there. You see, this is her testifying or telling the officer just within an hour or so of the alleged incident. So it's very fresh on her mind. You see her husband there with her. You can see her just pointing to where she was standing, to where the assailant was standing, and describing all of that. It's a critical piece of evidence that the jury was able to see.
Chanley Painter, live at the courthouse. Thank you so much. Now, the way the testimony about Kellen Winslow's bike rides in May 2018 came in was a bit unusual. I wasn't that happy about it, to be honest. But instead of bringing in employees of Strava or the developers of the app, no, Judge Bowman, he allowed a San Diego Police Department computer forensic examiner who also happens to use the app to come in and testify about what she found on Kellen Winslow's phone. Let's take another look at her testimony.
Now, you mentioned that there were various emails regarding Twitter activity. Can you describe what was located?
Again, one was from 2013, and it references using or starting cycling. Another was the fact that he tweeted, I just signed up for Strava.
And in terms of the user information for the Strava account, the email that stated "Welcome to Strava," was
But it
was
was
one of
to
the
one
two?
of those, yeah.
Okay, and both of them noting K2, correct?
Right.
Now, in terms of any additional email artifacts or internet artifacts regarding cycling, what else did you locate?
There was some registration for USA Cycling, another email talking about having the first amateur road race or first amateur race in January of 2015. There were receipts for a variety of Stinner bicycles, an email referencing a couple specialized bikes, specifically a Venge and a Shiv TT, like a time trial bike.
So, Ms. Rosa, let me just ask you, are you familiar with cycling?
Yes, sir.
How are you familiar with cycling?
I ride.
What does that mean?
Well, I guess in 2012 I started riding a road bike. It was the first time I'd ever ridden. My husband got me into it. And so I use the Strava app, and I've just basically used it as a fitness tool. Having had previous knee injuries, it's a better tool for me than running is. So that's why I do it.
When you're referencing some of these bicycles, can you explain to the jury, in terms of the receipts and the emails that were obtained on this laptop, what type of bicycles are those?
So a couple of them were road bikes. The Venge and one of the Stinners would be a typical road bike setup. One was a mountain bike, that was one of the Stinners. The TT would be a time trial bike. Typically those are the ones that are more aerodynamic and have different wheel sets to make it basically faster.
And in terms of the app that you mentioned, you are personally familiar with the Strava app, is that correct?
Yes, sir.
What's the Strava application?
Objection. Foundation, permission before doing witness.
Establishing the foundation order.
Overruled. They were attempting to lay the appropriate foundation. You can answer if you know.
So Strava is a mobile app that can be used to track a person's activities, including cycling, running, hiking, kayaking, skiing. It basically records the GPS route that you take. There are people who have created segments, and so a lot of times the users will measure themselves against other people who have completed those segments. It also enables the person using it to see what their top 3 scores are and gives virtual medals for that. It enables basically some trophies for top 10 of the segments, including, King of the Mountain, Queen of the Mountain, if you're the top person on that particular segment, regardless of your age or weight or anything. It's just an overall.
Is the application itself, is that something that's put onto a device?
Yes, you could use it straight from your phone, or you can have some type of GPS, like a Garmin or Forerunner, and then you can sync it to the Strava app. Sometimes you could do it through Garmin Connect, and then it'll download and sync to the Strava app. You can access Strava on the internet as well. It doesn't just have to be on the phone to be able to see what your activities were.
And in terms of accessing it, does it actually have a automatically generated report of the user's activities?
Yes.
Now, when you've used the Strava application, can you just describe how you used it?
I've used it both from my phone directly and also from using Garmin's. So when you use it on your phone, you just open up the application and then you would hit the record button and it asks you what type of activity you want to record. Typically it's either like a run or a cycle or a swim for the first ones that you can choose. And so you choose which one you want, and then it shows a map and gives you basically the little blue beacon of where you are. And then you hit start and it will basically route as you ride or run. And then when you're done, you hit finish and it will compile all the data and show you the map, show your average time, show you the amount of miles you went, the time of day, whatever types of information you have set. And when you use a Garmin, you can obviously have more items to be retained, and you can have a power meter on your bike, you can wear a heart rate monitor, and it all syncs to give you a better overview of the work that you put in.
And in terms of the GPS coordinates that are being automatically recorded when the user essentially hits the prompt of record, is that something that's then stored on the application platform itself that could be accessible through the internet or through the user's device?
Yes.
And when that is being recorded, in terms of your experience with the app, how is it that Strava obtains the GPS location information for the user when they're recording a ride?
So from the phone, it would be from the location services enabled on your phone for that application. If you're using a Garmin, then it would be when you actually upload that to the computer. Like if you physically connect it, all of the information is stored in that Garmin file, and then the GPS file that's on that Garmin, and then it would sync and upload.
In terms of your training experience as a forensic examiner, are you familiar with cell phone GPS technology?
Yes.
Can you just explain how a cell phone is able to be located in a particular geographic area based on GPS data?
Well,
it may be common sense at this point, but if you can explain based on your experience.
Well, whatever I use it for, it's basically for maps for directions, for Strava, and so my location services are enabled on my phone for those particular things, and so it will hit the various satellites to show me where I'm at, basically.
And is that the same technology that's used for the Strava application?
Yes.
Okay, we're going to take a quick break from looking back at some of the most compelling testimony in California versus Kellen Winslow II. Verdict Watch still on, day 4, over 15 hours.
Tonight on Court TV.
Verdict Watch continues in the trial of Kellen Winslow II after the jury requested a readback of Jane Doe number 4's testimony. Are they any closer to reaching a verdict? Stay with Court TV for the latest news, and we'll break down every development as we move closer to Winslow's verdict on all 12 counts of sexual misconduct. We're live in San Diego for the final moments in this trial.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
Welcome back to Court TV Live. We are in a Verdict Watch, day 4, hour 15 plus. This is California versus Kellen Winslow II. And let me tell you, a verdict can come in any second now, because it's not just day 4. It's not just past 15 hours. No. It is Friday, my friends. And you know what? Historically, statistically, juries come back with verdicts most often on a Friday because they don't want this lingering over the weekend. They don't want to have to come back on Monday. They don't want this weighing on them, spending the whole weekend worrying about this. So we are waiting with bated breath because we think that this verdict could come in any minute. So you're going to have to keep it right here. Let's go inside the courthouse to our Court TV crime and justice reporter, Julia Janae, who has been watching the comings and goings of the jury. Julia, what's the latest?
Seema, we are here in the hallway. We watched them come in, or come out of that room rather, and go back in. They've been back in now after the lunch hour for about 30 minutes now. It's 1:30 here on the West Coast, and that lunch break that they took, shorter than normal. They asked for a shorter one, which tells us that they are trying to move things along as much as possible. But otherwise, everything is quiet here on this hall. There's not a lot that's going on in these other courtrooms. And of course, the attorneys for both sides, they are not anywhere in sight because they will be waiting, like we are, for whatever comes out of that jury room. If there's a note, we will know about it, and we'll of course bring that to you. And if there is a verdict, we will bring that to you. But again, it is 1:30 here on the West Coast, and normally they have wrapped up things around 4:30 to 5 o'clock. So only 3 more hours before things should be getting extremely interesting here in Vista.
I can't believe things have been interesting all week for me. And this is, I can't believe it. It's Friday. I mean, you're a lawyer, you're a journalist. You know that Friday's usually the day, right, Julia?
This could beat the historic odds. I don't know, Seema, but I will tell you that if this does go against history and go against your statistics, then they will not be deliberating over the weekend. They would be coming back on Monday. So that would be what will happen if at the end of the day today they have not reached a verdict. But we are still waiting, and we'll of course bring you the very latest.
Good for them, good for us, and good for you because you can take care of that cold over the weekend. Thank you, Julia Janae. So, folks, we've been breaking down the testimony and the evidence surrounding all of the Jane Does just to bring it back to you because this deliberation's been going on for 4 days, and we want you to know why this is a nail-biter. Let me remind you, Kellen Winslow II is facing life in prison if he is convicted of all the charges. Now, let's talk about Jane Doe number 3. The evidence surrounding the accusations of Jane Doe number 3, she claims Kellen Winslow exposed himself while she was gardening in her front yard. Prosecutors called to the stand a computer forensic examiner to explain how the Strava cycling app, maybe some of you have it on your phones, that app confirms Winslow's movements on the day of the alleged incident. Can an app do all that? Let's watch some of the testimony and find out.
Now turning to Court's Exhibit 87 for identification. Is there another afternoon ride associated with the same Strava user account with the name Kellen Winslow Jr. and the photograph we just discussed?
Yes, sir.
And does that show that there was an afternoon ride on the day prior to May 24th?
Correct, it does.
What was the date that's associated with this printout?
It's Wednesday, May 23rd, 2018 at 4:15 p.m.
And does that show that there is a origin on the GPS coordinates that's contained here?
Yes.
And was that also in the city of Encinitas?
Yes.
And then was there a ride down the coast highway into Solana Beach down towards Del Mar?
Yes, correct.
Showing now Court's Exhibit 88. Does that show a close-up view of Lake Drive as it extends down to Birmingham Drive for this ride?
Yes, sir, it does.
And does it show the GPS track actually stops or continues and makes a loop into what would be the residence area of the homes that are near that corner of Lake Drive and Birmingham Drive?
Yes, sir.
Showing you now Court's Exhibit 89 for identification. Do you have that in front of you?
Yes.
Does that show the same user profile by the name of Kellen Winslow Jr. and the photo that we've identified?
Yes, sir.
And does that show an afternoon ride labeled for a particular date?
Yes, it does.
What's the date associated with this afternoon ride?
This one is Thursday, May 10th, 2018 at 2:45 p.m.
GPS coordinates that are associated with the ride on May 10th of 2018?
Yes.
And did that also originate in the Lake Drive area of Encinitas? Or the city of Encinitas?
Yes.
And did it extend down on El Camino Real to Manchester Road?
Correct, yes.
Showing you Court's Exhibit 90 for identification, does this show that on May 10th, the route taken by, that was automatically recorded by the GPS data, does that show that it extends southbound on Manchester Road near the 5 freeway?
Yes, sir, it does.
And does it show that the route taken went along Manchester Road and near the San Elijo Lagoon in a loop to the west of the 5 freeway?
Yes, sir, it does.
And it then continues on and extends through the Cardiff area of Encinitas and southbound on Coast Highway, is that right?
Yes, sir.
Just one moment, Your Honor.
All right.
Thank you. Nothing further, Your Honor.
All right, cross.
Just a couple questions. A Strava app user doesn't log into the app using a fingerprint, do they?
No, it's an email address and password.
There's no iris scan or anything like that?
Correct. No.
So it's possible that a person could use a registered user's Apple Watch or their Garmin, record a
Now, that was a very important witness to prove the charges with respect to Jane Doe number 3. Let's bring in criminal defense attorney DOD Ghassemkhani, who can help figure out why this random forensic examiner was allowed to come in and testify about the Strava app. Dodd, why wouldn't they call a representative from Strava? And I believe Strava's located in California. They could have just driven them down or something as convenient.
That's a great question, Seaman. That's the question that I've been wondering all along this entire trial. I believe what we heard at the trial was that the DA's office attempted to get a representative from Strava to come in and testify, and they were unable to. I believe that might have been heard in some of the pretrial hearings. But allowing a computer forensic expert to testify on the Strava app with no expertise at all in the Strava app, other than her being an avid biker, is extremely troubling. And Judge Bowman allowed it in as it goes to the weight of the evidence, not its admissibility. But at the end of the day, what does that really mean, weight versus admissibility? A jury doesn't know what that means. All a jury is going to look at is the actual map of the Strava, and it puts Mr. Winslow at or near the residence, and that's pretty damning evidence for the defense.
I love that you brought up weight versus admissibility, because I think it's an important point, and I think something our viewers are very interested in to know the legal machinations behind these rules. But again, right, the forensic examiner, excuse me, talking about GPS and those type of elements, completely fine. But an app that is much more complicated and was created by other people, is managed by a separate organization, it just doesn't make sense that she was allowed to bring it in. In fact, during the questioning in that soundbite, you heard that I think it was Prosecutor Owens asked her, "Oh, do you personally use the app?" What does that have to do with anything? If she personally uses the app, I've been using MyFitnessPal from December 2015. Is someone going to call me to testify about MyFitnessPal? Because if anybody knows how to use it, it's me. And okay, so here we're showing our viewers now the Strava, the map of the Strava route, which, you know, you really can't tell much, because if you're looking at this map, you could think, oh, maybe he just drove by and he saw her in the garden. It was that easy, but not so fast, because if you look at the body cam really was very introspective into this home. You know, you really get, it's almost like a maze the way this body cam follows this very lush, plush terrain that is, you know, this garden that's behind the house, not very easy to get to. You really have to maneuver your way around all these plants and the little sidewalk, the front yard area, kind of going off, you know, the body cam's following to the left of the home, and then again going a little bit farther into a path. So it's certainly not that easy. Now, if, let's just say, Winslow is convicted on these counts with respect to Jane Doe number 4, do you think the allowance of the Strava app evidence would be something the defense could appeal on?
Well, absolutely. I mean, when I look back on this case, I think there are several issues that could be brought up in appeal, and the number one issue I see is this Strava app. I mean, to allow this computer forensic expert who has no expertise in this app, who has no idea how the data is stored by Strava, to come in and testify that this is how the Strava app works and this is how the GPS, you know, tracking system works. You could have brought in anyone to testify that's used the Strava app to come in and say, well, I use the Strava app, and 99% of the time when I use the Strava app, it's accurate and it shows exactly where I biked to that day and came back. So I think that is extremely prejudicial, and it is something that will be looked at by an appellate court in the event of a conviction.
That's right. And I believe at some point I misspoke. We are talking about Jane Doe number 3 here. There are 5 accusers in total. Just reminding the viewers, there are 5 accusers. This was Jane Doe number 3. And also, this is the Jane Doe number 3 who did not identify him in a photo lineup. She never even was asked to identify him in court. She described him as being several inches shorter. She admitted she never looked at his face. So this Strava app could really be the nail in the coffin for Kellen Winslow II with respect to these charges. DOD Ghassemkhani, thank you so much for your expertise. And our verdict watch rolls on. Folks, a verdict could come in any minute now. It's Friday, it's day 4, and we are almost at 15 and a half hours. We're in a verdict watch. It's day 4 and about 15 and a half hours, and a verdict could come in any second, so you do not want to go anywhere. Kellen Winslow II, there's no question that he was a gifted athlete. He made All-State in 2001 when he was just a high school senior, and then he went on to win the NCAA National Championship the same year as a true freshman playing for the University of Miami, which makes the charges against him and this perceived fall from grace so much harder to understand? Our Court TV legal correspondent, Chanley Painter, explains.
From high school all the way to the NFL, Kellen Winslow II has commanded attention.
And all you had to do is look at his athletic resume to understand the talent.
He was somebody to watch.
Following in the footsteps of his Hall of Famer father, Kellen Winslow Sr., Winslow II carved an athletic legacy of his own. One Union Tribune sports columnist, Bryce Miller, followed for years.
One of the best players in football in San Diego history, and by default in California history. Even in high school, he was one of the best to ever play in state history.
At Scripps Ranch High School in 2001, a teenage Winslow was already making headlines. He earned All-State in football, gaining the attention of college recruiters across the nation.
My dad and I, we couldn't come to an agreement on which school I should go to. I wanted to go to Washington. He wanted me to go to Michigan State. I was like, you know what? I'm just gonna go to Miami.
He was very angry at his father for blocking his way to Washington at that point. Later, he would go on to say it was a great decision. I'm glad he ended up at Miami. That was a moment where father and son had to sort through something that was a clear moment of conflict.
During his freshman year at the University of Miami in 2001, Winslow played as a starter for the Hurricanes. That year, his team would go all the way.
I guess if you win a national championship your first time out, and a couple years later win the Mackey Award, it's hard not to think it's a good decision.
Winslow decided to forego his senior year of college, allowing the Cleveland Browns to select him as the 6th overall pick in the 2004 NFL Draft.
That's the reason I wore 81, because I wanted to be one better than them. I wanted to be one better than my dad.
In 2004, Winslow signed the largest rookie contract for a tight end in the league's history. He would go on to play only 2 games before breaking his leg on the field. And the following year, a motorcycle accident threatened the same leg. Doctors feared amputation. But beating the odds, Winslow recovered and returned to the gridiron.
Well, Kellen's reputation, I mean, he's a great football player. He was a better athlete than his father. I mean, but there's a difference between being a better athlete and having a better career.
Veteran sports analyst and former NFL player Jamie Duke says Winslow helped evolve the tight end position.
A guy who was undersized for a prototypical tight end, being able to have a guy in line, lined up with the offensive lineman, and then running routes with that kind of speed, he probably was, and still may be, well, one of the best athletes to be that new generation of tight end.
Winslow played for 4 teams in his 10-year NFL career, including the Cleveland Browns, Tampa Bay Buccaneers, New England Patriots, and New York Jets. During that time, he caught 469 receptions, scored 25 touchdowns, and had over 5,000 receiving yards.
But I know he caught a lot of balls. K2 was more of he moved around the several teams, and when you start moving around teams, that basically, pretty much eliminates any opportunity probably for you to reach the Hall and have that kind of career.
Winslow made the NFL Pro Bowl team in 2008, and when he left the NFL in 2014, his time in the spotlight faded until allegations of rape put a microscope on the sports star's behavior.
For Winslow to stand trial on 2 counts, forcible rape and rape of an unconscious person.
The son of Chargers star Kellen Winslow, Kellen Jr., is a member of he was a tight end in the NFL for 10 years himself.
You immediately knew that this was something that people were going to pay attention to.
Me personally, knowing his dad and what type of player he is, I don't think he did it.
Former Browns player C.J. Jones says the allegations do not match the man he knew as a teammate.
I don't think he raped him. He even got to do that. It's Kellen Winslow, man. I don't think he has to do that.
Now, behind the doors of a San Diego courthouse, the people depict the former player as a predator.
You will learn over the course of the next few weeks that Kellen Winslow took what he wanted. He took what he wanted not from one, not from two, but 3 women. He victimized 5 women.
Kellen's defense calls the charges false and the high cost of his celebrity.
He's been in the spotlight since he was young. When you're in the spotlight, people want things from you. And that's just the way it is.
The final outcome rests in the hands of a jury of 12, tasked with deciding where Winslow's legacy goes from here.
Will this NFL star be set free, or will he go to prison for the rest of his life? It's in the hands of the jury, and we are expecting a verdict at any moment. The Verdict Watch continues after this. We are in a Verdict Watch. It's California versus Kellen Winslow II. Welcome to Court TV Live. In day 4 of deliberations in the Kellen Winslow rape trial, the jury has had the case now for over 15 and a half hours over the span of, yes, just like I said, 4 days. Now we have Court TV's legal correspondent Chanley Painter, who's been inside the courthouse throughout the duration, and we have crime and justice reporter Julia Janae, who has been, Julia Janae's inside the courthouse. Chanley Painter's outside the courthouse. Court TV has this covered from door to door. Let's start off with Chanley Painter. Chanley, it has certainly been a chaotic 24 plus hours between the readback of Jane Doe number 4, the readback of Jane Doe number 4's friend Nicole Edwards, and then we had yet another jury note today. So if you just don't mind bringing our viewers up to speed, take us back to that Jane Doe number 4 note. The jury requested her testimony as well as Nicole Edwards, and they've requested some text messages that they did not receive.
Right, that was the note yesterday, right before lunchtime here in Vista. The jury sent a note saying, we would like to have a readback of Jane Doe number 4's testimony and Nicole Edwards' testimony. They also asked about exhibit number 154. It wasn't in there with them, so they were wondering about that. Well, they spent the lunch break, the court reporter put all of that together, so it took about a couple of hours, and all the attorneys, the defendant, the jurors gathered into the courtroom yesterday afternoon, and the reporter read the transcript from Jane Doe number 4's testimony, got almost all the way through it, but the judge did address the exhibit. He said that they will not receive that exhibit. It was taken out of evidence as the defense objected. It was hearsay, and that was sustained, and so... But if you were listening to the testimony, they did refer to it in the readback, and the jury was noting down whenever they were talking about number 154. And then this morning, we continued with the readback of Jane Doe number 4, moved on to Nicole Edwards as well, and right at the break time between those two, the jury left for a break, Seema, and that's when the foreperson gave a note to the bailiff, and we had the next question from the jury, and that was what was addressed today. And it said, hey, it would help us if you could define what under oath actually means, and also, let's see the second one, how to follow the law and not what we think the law should be. So those were the two things they asked about this morning, and the judge did address those as well.
So with respect to the Jane Doe 4 readback, yesterday the readback took, I think, over 2 hours, and I want you to correct me if I'm wrong about that, but it seemed like that readback took over 2 hours. There were some breaks in there, and what I found quite compelling was the delivery by the court reporter. Even though, and as she's instructed, these court reporters, they're told you just have to say the words, you can't inflect, you can't show emotion, you can't be animated. But because the words she was saying was so powerful, I felt almost as glued to the court reporter's readback than I did to the original testimony. So I'm wondering, how did the jurors react when they heard that readback of Jane Doe number 4?
I was watching the jury quite closely, and it was pretty telling when they were taking notes and when they weren't taking notes. And it's kind of a good thing. She's easy to listen to. That's good because it is a couple hours of read back of testimony. So what I noticed, Seema, was the jury, most of them, not all of them, most of them just furiously taking notes when she got to the part about the events leading up to the alleged incident and what happened back in 2003 between Jane Doe 4 and Kellen Winslow II. And then their note-taking sort of waned off a little bit after that. And even when cross-examination time came, there weren't many notes being taken except for a couple of noticeable jurors. Mostly number 2 and 12 were very much taking notes, especially when 4 was being cross-examined on the inconsistencies in her stories. And the 4 person seems pretty even-keeled throughout all of it. He's taking copious notes as he's done every day during the trial.
And as we know, it only takes one juror to get some readback. So that could have been the case. Now, there was an interesting moment during the readback of Jane Doe number 4's testimony and Kellen Winslow's reaction. So let's play that for our viewers.
Question: what happened after Kellen left the room? Answer: Matt started to help me get dressed. Question: after Matt started to help you get dressed, did Kellen come back into the room at all? Answer: he looked, I don't know if he came in fully, but I know he came in back and he says, she's just a stupid bitch, and then closes the door.
We actually have a closer look at that same clip, a closer look at Kellen Winslow. Let's check this out.
After Matt started to help you get dressed, did Kellen come back into the room at all? Answer: he looked, I don't know if he came in fully, but I know he came in back and he says, she's just a stupid bitch, and then closes the door.
So that was really subtle, Chanley, as you saw, Kellen Winslow just did this like tiny little flick as to say, no, it looked like to me at least, as he was saying, no, that's not true. I didn't say stupid bitch. But when Jane Doe number 4 testified and said those words, his head, as you remember, was completely down, focused on his note taking, and there was no reaction at all. Did you find Mr. Winslow to be more reactive or less reactive or something in the middle during the readback?
Definitely. He's been more open with his reactions throughout the entire readback. Even how he enters the courtroom, he seems quite a bit different than when the trial was actually taking place. And that was just one instance of many times where he shakes his head in disagreement. And it's more noticeable when the jury was out on a break and the judge was talking to the attorneys on how to answer the note this morning. He was almost participating, it seemed like, with what he thought the answer should be with his attorneys, and that is very telling. He sits there and he's watching the jury react to the readback. He's paying a lot of attention. Usually we see him just taking notes or looking down at his table and passing papers to his attorneys, but not during the readback. It's a very different Kellen Winslow II.
I wonder if it's because the witnesses, including the Jane Does, including the civilian witnesses, law enforcement witnesses, just all of them, he found to be more intimidating. Like maybe he was just told to behave a certain way and keep his head down and take notes. And then during the readback, in a way, he feels more free to be himself. I don't know. But Chanley Painter, thank you so much for your reporting, my friend. Let's bring in CourtTV's crime and justice reporter, Julia Janae, who is inside the courthouse, who has been glued to the comings and goings of this jury. Julia, any movement since they've gotten back from lunch? Have your eyes been fixed on that deliberation room?
They have been peeled, Seema, but absolutely no movement from this jury, no notes, no buzzing to the bailiffs to come in. Everything has been completely quiet here on a Friday afternoon in this courtroom and on this third floor where they are behind that door deliberating. So now it's been about an hour and a half that they have been deliberating since their lunch break. They are inside, we know, diligently going through all of this information.
Now, the last note that we received, it was several hours ago now. Actually, before I ask you a question about it, let's play some sound from Judge Bowman on the last note, which I think is a third note from the jury.
I just received the note before he went out from the foreperson. It was handed to the bailiff. The bailiff just handed it to me. The note reads as follows. There's two sections to the note. The first part says, the jurors could benefit from an explanation as to what being under oath means. So I will explain a little bit further what being under oath means. You have all heard every witness who comes into the courtroom take an oath to tell the truth. And that is an oath where they have to agree to tell the truth, the whole truth, and nothing but the truth. And that oath requires them to, when they take the stand, not only here at trial, but also at the preliminary hearing that was held some time ago, that requires that witness to testify truthfully. If they do not testify truthfully under oath, they are subject to the penalties of perjury of the state of California. Now, I hope that answers the question, but when somebody takes an oath to tell the truth, they have to tell the truth, the whole truth, and nothing but the truth. And you heard over 30 witnesses.
So, Julia, that note came in at approximately 2 p.m. Eastern time, which is 11 a.m. Pacific time. So now it's about 3 hours, a little more later. What has the jury been up to in the last 3 hours?
Well, I'll tell you, the timing of that note was particularly interesting because it didn't come out of the room that we've been watching. It came at a time that they were in the courtroom for already a certain amount of time, probably about 30 minutes. They had taken a break, and when they came back from their break, so not from deliberations, but they came back from their break, is when that note was passed to the bailiff and then provided to the judge. It actually came rather before they went on their break. So this was passed to the judge at a time that they had not been in deliberations. So it just is an interesting timing that that note came out. It tells us maybe that the foreman wrote this note perhaps during the readback, or if he wrote it while they were in deliberations, he held it and didn't pass it to the judge until after they had gotten through about half of today's readback. But in answer to your question, since they have given that note over to the judge and then received the instructions or reiteration of the instructions from the judge, they then finished out the readback of the testimony of Nicole Edwards, and they then were released back to deliberations. After that, they went to lunch for an hour, and they've returned here and again been in deliberations for a little over an hour now.
Okay, Julia Janae, I know you will come back to us the minute you hear anything. Thank you so much. And listen, folks, we're on a verdict watch, but the minute either Julia Janae or Chanley Painter or any of our CourtTV team in San Diego hears anything, we are going to bring that to you immediately, and we're going to bring it to you live. We're in a verdict watch, day 4. Any second now, the jury could come back with a verdict. That's right, it's day 4, approaching 16 hours of jury deliberations. We're on a verdict watch. Now, we've been looking back at the case against Kellen Winslow II. Right now, we're going to take a closer look at the investigation into Jane Doe No. 1's case. Some consider Jane Doe No. 1's testimony to be the weakest of the other accusers. However, Winslow's DNA was detected on her pants, so there is evidence of some type of incident, but Jane Doe No. 1 was unable to identify her alleged assailant, and there was also some conflicting testimony about what caused the blood stain on her white pants. Detective Mike Benavidez investigated her case and testified about how difficult it was to get in touch with Jane Doe No. 1. Let's go back and watch some of that riveting testimony.
All right, next witness.
Thank you, Your Honor. The people recall Detective Mike Benavidez.
All right. You're still under oath, so you can come on up. All right, and as I indicated, you're still under oath from this morning. All right, so direct examination.
Thank you very much, Your Honor. Detective Benavidez, have you been present during the testimony of Jane Doe No. 1?
Yes.
Now, I'm going to ask you in addition to some of the things we talked about this morning during your testimony regarding the collection of evidence, I'm going to ask you about some dates and time that relate to your investigation into the reported sexual assault of Jane Doe number 1. Now, was the first contact, based upon your knowledge, the first contact that she had with law enforcement after this incident, March 21st of 2018?
Yes.
Did the deputy who took that report, was that Deputy Stevens?
Yes.
Did you in fact review the recorded interview on a body-worn camera video recorder of the contact between Deputy Stevens and Jane Doe 1?
Yes.
When, as you said this morning, you were assigned the case for follow-up within a couple of days, I think you said March 25th of 2018, was that one of the first things you did?
Yes.
Why was it that you reviewed the initial point of contact interview from the sheriff's deputy with Jane Doe 1?
Just to clarify the statement she provided to Deputy Stevens.
And in terms of you as the sexual assault detective, when you're following up on a crime report, is it fair to say that at least in terms of your experience, that the initial contact for a crime report may be more limited questioning than a follow-up interview?
Yes.
What did you do after reviewing the first recording of Deputy Stevens' interview with Jane Doe 1?
I telephoned Jane Doe number 1, requested to meet with her in person for a formal interview.
Why did you do that?
Just so I can clarify her statement and see if she had any additional information to provide.
And do you recall the date that you first attempted to make contact with Jane Doe 1?
I had to refer to my notes, the exact date.
If that would refresh your recollection
Yes.
as to the efforts you made to contact her and interview her, please do.
March 30th is when I telephoned her.
So if you were assigned the case on March 25th, you reviewed the interview, you attempted to contact her on March 30th, is that right?
Yes.
Now, once you had attempted to contact her, were you successful in actually reaching her initially?
No.
What did you do?
I left her a voicemail, gave her my contact information to call me.
Did you receive a return call?
No.
What did you do after that?
I actually telephoned the area detective at the station to obtain more information about the case.
And after doing that, did you ultimately attempt to contact Jane Doe number 1 again?
Yes.
When did you do that?
I did that on April 18th.
Now, we're talking about over a month after the incident and nearly a month after she first reported it. Did you ever receive any additional contact or intervening contact from Jane Doe 1 in response to your first voicemail?
No.
Is it fair to say that she wasn't banging down your door trying to find you?
That's correct.
Now, based upon the lack of contact with Jane Doe number 1, was there a decision made to suspend your investigation at a certain point?
Yes.
Now, you were present during the questioning of Jane Doe 1 as it related to whether or not she elected to participate in a sexual assault examination. Do you recall that testimony by her?
Yes.
Can you explain to the jury how it is that you explained to a reported victim of sexual assault her options in terms of whether or not she would like to complete a sexual assault exam?
Well, every victim that I have of a sexual assault, we do offer a SART exam with the forensic nurse, and I explain the process as far as the questioning. There's examination done by the forensic nurse, and when we do bring him or her to the SART facility, that forensic nurse again explains in detail the process.
And do you explain to them at the outset that it is their right to either participate in one or to decline one?
Yes.
Did you ever personally have that conversation with Jane Doe 1 as it related to this case?
As far as offering a SART?
Did you? Yes.
I didn't offer a SART because when I watched the body-worn camera, Deputy Stevens had offered the SART.
And that was my next question. Was there in fact the time on March 21st when Deputy Stevens, based on your review of the recording, had actually done that already?
Yes, he did.
And did he ask her if she would like to go to the hospital to complete a sexual assault exam?
Yes, he did.
Did she decline?
She declined.
Did he tell her that it was her right to either accept it or to decline it?
Yes.
Okay, we just hit the 16-hour mark. It is day 4. We're on a verdict watch. A verdict could come in any second now in California versus Kellen Winslow II. We are on a verdict watch. A verdict could come down any second now in California versus Kellen Winslow II. The jury has had the case for 16 plus hours. This is day 4. And it's Friday. And you know what? Historically, statistically, juries come back most often on Fridays. And let me just remind you, Kellen Winslow II is facing 5 accusers, charges that span from 2003 until 2019. Now we're taking a look at all the accusers. Specifically, right now, let's take a closer look at the investigation into Jane Doe No. 1's case. Detective Mike Benavidez investigated the alleged rape of Jane Doe No. 1. He testified about the photo lineup that he showed her. Now let's go back and watch more of his testimony.
Now, when, based upon your experience when you're conducting a sexual assault investigation, do you oftentimes see individuals who decline to participate in a SART exam?
Yes.
Have you personally been present during at least the initial portion of a sexual assault exam where the SANE is explaining to the reported victim that what her options are?
Yes.
And that what the actual process itself entails?
Yes.
Would you characterize it as an invasive physical process?
No, I would not an invasive. It's just a collection of evidence.
Now, at least as it relates to Jane Doe 1, you were never involved in a direct conversation with her about her reasons for not wanting to participate in the sexual assault exam, right?
No.
So then moving forward, from the time that you attempted to contact her again in April of 2018, do you recall when it was that the case was formally suspended?
I'm referring to my notes here.
Please do, if it would refresh your recollection as to that date.
On April 26th.
Now, what was it that came to light that reopened that case investigation into the incident that Jane Doe 1 reported?
When there was another reported incident in Encinitas that Detective Johnson had received.
And I think that we discussed it briefly this morning during your testimony, but were you in fact contacted by Detective Johnson, who worked within your same sexual assault unit, about a separately reported stranger rape?
Yes.
You already described what a stranger rape is, but what was it about the separately reported incident that had common characteristics with yours?
The suspect description and the vehicle description.
Do you recall what about the suspect description in your case was similar to the other case?
A light-skinned black male.
Was there a description of tattoos extending from the arm all the way up to the shoulder?
Yes.
Was there a description of the vehicle?
Yes.
And what were the common attributes regarding the description of the vehicle?
A black-colored sports utility vehicle, SUV.
Now, you heard the testimony of Jane Doe 1 and you reviewed the video recording with Deputy Stevens. Did she in fact initially describe the vehicle as a Hummer or like a Jeep?
A Jeep.
And when you spoke to her ultimately on June 12th of 2018, was that in fact the second time that you had personally met with her?
Yes.
Do you recall the specific date that Detective Johnson reached out to you regarding his sexual assault investigation?
I do not.
When was the first time that you met with Jane Doe 1?
When I showed her a photographic lineup and obtained her DNA oral reference swab.
Did that take place on May 17th of 2018?
Yes.
Now, sometime between when Detective Johnson's investigation was initiated and May 17th of 2018, is that about the time frame when you would have had conversations with him about the common features between the two?
Yes.
On May 17th, how did you reach out to Jane Doe 1 and ultimately meet with her?
I called her and requested that she meet with me, and she agreed.
So she answered the phone this time?
Yes.
What do you recall explaining to her what the reason was as to why you wanted to meet with her now?
Well, I told her that we had a similar incident that may or may not be related to her case, and I requested that she use a photographic lineup.
And did you in fact go to meet with her to show her a photographic lineup?
Yes.
How is it that you develop a photographic lineup in order to show to a potential witness?
We have a potential suspect identified, and that person is placed in a set of photographs, of 6 photographs with 5 similar facial characteristics.
At that point in the investigation, did you have a potential suspect identified?
Yes.
Who was it?
Kellen Winslow, Jr.
How was it that, and is that the same person you've identified in court?
Yes.
How was it that you had, at least at that point, identified Mr. Winslow as a person of interest, at least within the sheriff's department?
Just based on Detective Johnson's report, or the incident is very similar to my case.
And obviously we're somewhat out of order chronologically, but was there in fact a positive identification of Kellen Winslow on May 14th of 2018 in that sexual assault investigation?
Referring to Detective Johnson's case?
Yes.
Yes.
So then on May 17th of 2018, as you're meeting with Jane Doe 1, did you attempt to show her a photographic lineup that included a picture of Mr. Winslow?
Yes.
If I may just have one moment to switch over to...
Okay.
Thank you, Your Honor.
Let's break down the investigation into Jane Doe number 1 with criminal defense attorney DOD Ghassemkhani, who is still with us live from the San Diego courthouse. DOD, this was a convoluted situation, needless to say, with Jane Doe number 1. First, she didn't report for 4 days, which is fine. She decides that she doesn't want to do the SART exam when she does report, and then at some point, this detective can't find her. But you and I have been through this, okay? As lawyers, this happens with clients, with witnesses. Oftentimes, people, regular folks, aren't married to their cell phones like lawyers, like us, right? So sometimes we do have trouble keeping in contact. But the question is, does that necessarily mean the crime didn't occur just because your witness may not be the most reliable?
Well, absolutely not. I mean, as you said, I mean, we've tried these cases, and there's really no perfect way for any victim to act. But what I think is the most telling with Jane Doe 1 is the whole defense theory of, this is a money grab. This is a money grab. Well, if this was really a money grab, you would think that Jane Doe 1 would not only report right away, she would follow up with the detectives. When she was contacted by the detectives, she would follow up with them right away. So the defense's theory that this is all a money grab and everyone's going after Mr. Winslow's money in this case is very inconsistent with the fact that they had to suspend the investigation until Jane Doe 2 came forward.
Exactly. They had to suspend until Jane Doe 2 came forward. But okay, so do you think that this is the normal practice of law enforcement to perhaps look at another crime and then go back and say, wait a minute, this fits the pattern of a previous complaint that we received a few months ago, a few years ago, maybe?
Well, absolutely. I mean, their case is only as strong as their victim. And if the victim is going to call and make a report of sexual assault, and then they're going to follow up with her, and she's not going to call them back, there's only so much that the detectives can do at this point. And I believe, they did the right thing. They suspended the investigation. They tried to contact her for, I believe it was almost a month, and she wouldn't contact them. So there's really not much more that the detectives could have done at that point.
And you just said the case is as strongest as their latest victim, which brings me to the jury instruction with respect to Jane Doe number 2 and Jane Doe number 1. You remember there's that instruction that says if the jury finds beyond a reasonable doubt the accusations supporting Jane Doe number 2, then they can use that as a factor in considering the charges against Jane Doe number, or charges with respect to the accusations involving Jane Doe number 1. So you can take what you find from Jane Doe number 2 and use it for Jane Doe number 1. And also, D.A. Owens, he opened his closing argument talking not about Jane Doe number 1, not about the first who testified, but Jane Doe number 2. So is this in a way a backdoor avenue to get a guilty conviction for the charges with Jane Doe number 1 and avoid all this inconsistencies that she created?
Well, absolutely. I mean, the way the case was brought from the beginning is to get a guilty conviction on all Jane Does. I mean, they consolidated all the cases, and by consolidating the cases, it already puts Mr. Winslow at a significant disadvantage by having the jury hear all 5 Jane Does in one trial. Now, with respect to that jury instruction that you're talking about, I believe it's Cal Crim 354 as it relates to the propensity of Mr. Winslow. And the argument Mr. Winslow made is if you believe he's a sexual deviant and you believe he committed this act beyond a reasonable doubt, you can consider that in whether or not he committed the crime on Jane Doe number 1.
Yes, absolutely. And I think that's certainly what's occurring here. But it does seem that the jury is following the law, because if, listen, this guilt by association, having so many accusers, if the jury was going to say, okay, this just looks bad, guilty on 1, guilty on all, but just because we're here, it's day 4, it's 16 plus hours. It is Friday evening, rapidly approaching on the east, certainly approaching on the west, and they're still hard at work, which leads us all to believe they are following the law and they are looking at each of these cases separately. Dodd, thank you so much for your expertise. Now I want to bring in Chanley Painter, our Court TV legal correspondent.